Reeves Immigration Law Group now brings you Immigration Law on Your Side.
Magandang gabi mga kababayan and welcome to another edition ng ating Immigration Law on Your Side. Dito pa rin sa PHLV Radio. Happy Wednesday evening po sa inyong lahat. And if you're watching us or listening to us on our podcasts, on our on-demand platforms, magandang araw, magandang gabi kung nasaan man po kayo ng lupalop ng mundo. Maraming salamat po sa pag-join niyo sa amin muli dito sa Immigration Law on Your Side. Maganda po ang topic natin yung gabi and because as you know, mga kababayan, due to the potentially very, very lengthy wait before the beneficiary of an approved petition is allowed entry to the United States, to immigrate to the United States, there is the very real possibility of the petitioner's death. Naitanong nyo na ito dito sa PHLV Radio. Paano anyay kung ang ating petitioner ay namatay? Ang ating petition ba ay buhay pa? Aalamin po natin ngayon kay Attorney Flomi Javier Diza. He is coming to us from Reeves Immigration Law Group in San Francisco, California. Magandang gabi po sa iyo, Attorney Diza.
Yes, Kuya Yo, magandang gabi po sa lahat ng mga listeners and viewers sa West Coast at magandang umaga po sa Pilipinas. At kung kayo po ay nanonood, today is Wednesday, as you said, it's another Wednesday at we are here at PHLV Radio on Immigration Law on Your Side. Very timely ang ating discussion, dahil marami sa mga kliyente natin ang nagtatanong at nag-email regarding this issue, death of the petitioner. This is always a recurring problem at issues lalo sa ating mga kababayang Pilipino dahil sa waiting time. Yung sa preference category, ang family-based preference petitioning married children, it will take about 20 years. Sibling petition is over 20 years. And even unmarried children of a lawful permanent resident or a U.S. citizen, Kuya Yo, ang processing time or priority date waiting is about 8 to 12 years pa rin. So during that process, as you mentioned, there's a possibility that the petitioner will pass, or mamatay yung petitioner. At may mga paraan naman, although it's a very tragic event sa buhay natin kung tayo'y namatayan, lalong-lalo na kung may pending petition, the possibility of the beneficiary to come to the United States, baka mawala yan, at the same time grieving of a lost family member.
Ito, attorney, yung sinasabi nilang double tragedy. Nawala na yung kapamilya nila, ay nawala pa rin ang kanilang dream to immigrate to the United States. Ano po?
That's correct. But it's not the end of the world, Kuya Yo. At may mga paraan naman yan para sila makarating pa rin dito sa US at ito ay ating pag-uusapan ngayon. Right, very timely ang ating discussion dahil as we mentioned, yung waiting time. So, unahin muna natin, Kuya Yo, yung discuss muna natin or breakdown natin yung ating discussion, right, dun sa posibleng scenarios kung sakaling mamatay yung petitioner. Unang-una po diyan yung spouse ng US citizen. Kung namatay yung petitioner, mayroon tayong tinatawag ng widow or widower petition. Pangalawa dyan, Kuya Yo, yung 204L, yung Immigration and Nationality Act law that was passed during Obama's time. This is a law that would allow surviving family member to be able to adjust his status in the U.S. despite the death of the petitioner, provided that the beneficiary or any of the principal beneficiaries resided in the U.S. Upon the death ng petitioner. At pangatlo, yung very common dyan, lalong-lalo na nasa Pilipinas, ay yung humanitarian reinstatement. The rule is that once the petitioner pass away, the petition is automatically revoked under the Immigration and Nationality Act. But in certain situations, pag-usapan natin mamaya kung ano yung mga factors to consider para sa discretionary approval ng Attorney General para reinstate ang approved petition even with the death ng petitioner.
Mm-hmm. So marami pa palang mga paraan, mga kababayan. It's not the end of the road, sabi nga ni Attorney Diza, kung ito ay sumapit sa inyo, itong situation na ito. So now, Attorney, let's talk about the widows or the widowers petition na nabanggit nyo. How does this work, Attorney?
Yes, the beneficiary must be married to a United States citizen, Kuya Yo. At kung namatay yung petitioner, the widow, the widower, is able to file a widow spouse petition on the form I-360. So yung family-based petition, di ba, I-130, but for a widow spouse petition is I-360 ang gagamitin. So in the past, kailangan i-prove, Kuya Yo, that they were married for 2 years. Right? But that was eliminated. No? So yung bagong batas natin, so kahit kakasal mo ngayon, right, and then may nangyari sa petitioner or US citizen, kinabukasan, or even if the marriage is less than 2 years, the beneficiary is able to file the widow spouse petition. So regardless of where the beneficiary is residing, nasa Amerika siya or nasa ibang bansa, outside the US, for example sa Pilipinas, pwede pa rin i-file ang 360. So that is a possible scenario, yung unang scenario, na wala pang i-file, mag-file pa siya ng 360. Now, assuming that the I-130, yung immigrant visa petition has been filed already at namatay yung petitioner, automatically kino-convert yan. Pag sinabihan mo na ang USCIS that the petitioner passed away, i-convert nila yan sa I-360. So kung na-approve na yung petition, tuloy-tuloy pa rin ang petition. So 360 pa rin ang basis ng pag-adjust ng status o pagkuha ng green card. So it's really very important, lalo na kung walang kamag-anak dito yung tawag nito, yung beneficiary at namatay yung asawa, one of the requirements, as we discussed in our previous episodes, that the beneficiary has to have a affidavit support, So in this situation, Kuya Yo, exempted ang mga widower sa pagpa-file ng affidavit support. So hindi nila kailangan, siyempre kasi patay na yung kanilang asawa or petitioner, hindi na rin nila kailangan ang joint sponsor. So under the law, exempted po sila. So that's really a very good thing para tuloy-tuloy ang pag-process ng kanilang green card or pag-process ng kanilang adjustment of status pag nasa Pilipinas sila.
Mhm. May naitanong sa atin, attorney, related dito sa issue na ito. What if nag-remarry itong beneficiary dahil namatay yung kanyang spouse,
Yeah, unfortunately, hindi siya pwede mag-avail dito sa widow spouse petition, Kuya Yo, upon the remarriage ng beneficiary. So essentially, hihintayin ho ang green card, right, or visa, yung widow bago siya magpakasal ulit. So darating muna siya dito, kunin ang kanyang green card at balikan kung mayroon man siyang girlfriend o boyfriend na naiiwan, di ba? Kasi otherwise mananalify ang I-360 petition. So maghintay po ng konti para lang para makakuha mo ng green card. But of course, pag nasa US yung beneficiary at nagpakasal siya ulit ng panibagong US citizen, then the basis for the green card would be with the new spouse. But for people who are intending to marry non-US citizen, they have to wait for the actual green card and the visa before they're able to get married para lang ma-preserve ang kanilang green card or immigrant visa.
At makarating na muna dito sa Amerika.
Correct.
Oo. Ayun. So ito po mga kababayan, this is the first one, yung widow and widower petition para kung namatay ang petitioner ninyo. As outlined by Attorney Diza a while ago, there are other things that can be done. Ito pong attorney niya na outline nyo kaninang 204L. Paano po naman ito nag-work?
Yes, as we mentioned, this was passed only in 2009 under President Obama. That helps a lot of people, a lot of our kababayan who are already in the United States. So take note, Kuya Yo, ang humanitarian reinstatement, just to segue a little bit, compared to 204L, the petitioner passed away, right? But in 204L, if the principal beneficiary passed away, right?
Oh, okay.
Pwede pang makakuha yung mga derivative. So either yung asawa o yung mga anak na minor, pwede pa silang makakuha ang green card. Unfortunately for humanitarian reinstatement, hindi eh. So let's say, pinetition mo yung anak mo na may asawa at 5 minor children, namatay po yung petitioner, pwede mag-reinstatement. Pero kung ang namatay ay yung principal beneficiary, yung pinipetition, Kuya Yo, so wala na pag-asa ang asawa, wala na pag-asa mga anak. But under 204L, one of the advantages of this law is that the derivative beneficiary can also avail of this law in order to get the green card. But take note mga kababayan, ang 204L applies only for people who who are here in the US or who are here in the US when the petitioner passed away. Any of the beneficiary, either rather the principal beneficiary or any of the derivative beneficiaries na nandito. So yun ang kinaganda ng 204L. So ang importante dito Kuya Yo is that bago mamatay yung petitioner o yung beneficiary, may petition na naka-file, di ba? Number one. And number two, as we mentioned, either one of the principal beneficiary or derivative beneficiaries resided in the United States when the petitioner passed away. And then also kailangan din i-provide siyempre yung sinasabi nating substitute sponsor. This applies to both the 204L and reinstatement, right? Na mayroong substitute sponsor, and very specific kung sino ang substitute. Kasi hindi pwedeng kung sino lang, di ba? Hindi kagaya ng joint sponsor na any US citizen over 18 years old or a lawful permanent resident related to the beneficiary or not, pwede mag-execute ng joint sponsor. Pero para sa 204L and also the humanitarian reinstatement, kailangan ang substitute sponsor either be a child or children, son or daughter over 18, or parents, mother, father, siblings, and pwede rin mga in-laws, Kuya Yo. So, very important yan na mayroong magsa-substitute sponsor under those mentioned relatives. So, that is one of the requirements ng 204L and also for the humanitarian reinstatement. And as we mentioned, Kuya Yo, ang kinaganda nitong 204L is hindi mo kailangang i-prove yung factors doon sa humanitarian reinstatement. Kailangan mo lang i-prove, Kuya Yo, is nandito ka, di ba, nung namatay yung petitioner. Pangalawa, meron kang substitute sponsor. You don't have to prove any kind of factors like disruption of family unity or anything like that. Hindi mo na rin pwede hindi ka rin magpa-file ng reconsideration. So let's say Kuya Yo, pinailan si Juan de la Cruz ng petition ng kanyang tatay in in 2000, right? At nandito na siya. Alam natin na ang married child or married son of a US citizen takes about 20 years ngayon. So then naghintay siya dahil sa tagal ng panahon namatay yung petitioner. Pero si Juan nandito nung 1998 pa, right? And then naging current yung priority date niya, for example, this year. Naghintay siya ng 20 years, pero 5 years ago, namatay na yung petitioner. So then, si Juan would be able to get the green card. Of course, you have to consider then, Kuya Yo, that Juan is admissible, meaning ang violation lang yung overstay, but because he's subject yung 245I na nabanggit natin in our previous discussion, where there was a petition filed before 2001, he is able to adjust, at meron din siyang kapatid na mag-execute ng affidavit support. So that is a good example. Or halimbawa si Juan wala dito sa Amerika pero meron siyang anak, right? So halimbawa nagpunta dito isang anak niya at nag-aral, nag-apply ng student visa, nag-aral dito pero nung natapos ang kanyang term, ang kanyang schooling, nag-overstay na siya. He decided to overstay at nandito pa siya nung namatay yung kanyang lolo. So itong anak ni Juan na nasa United States would be able to adjust the status under 204L, right? As a derivative. Now, si Juan na nasa Pilipinas din, pwede rin siyang pumunta dito. Hindi reinstatement ang gagawin, kundi yung under 204L na mas lenient compared sa humanitarian reinstatement. So marami sa ating mga kababayan na hindi alam ang 204L. This is really very helpful sa ating mga kababayan. And believe me, Kuya Yo, ang dami-daming mga nagko-consult na, when we discuss this law, they were surprised that this applies to them. A good example as well is that, for example, yung isang client natin where yung kanyang asawa ay pinetition ng employer. So yung I-140 petition as a civil engineer, and siyempre may asawa siya, mayroon siyang 3 anak na minor. And then of course, nag-labor certification of course yung kanyang employer na approve. And then while waiting for the priority date, right, namatay yung principal beneficiary, yung pinipetition na civil engineer. So then the prior attorney said na wala ng pag-asa, right? So kasi siya ang principal. And then of course yung widow consulted with us and said wala ano na pang option niya kasi mga anak niya mag-age out niya siya, wala na ring status and everything. But we evaluated the case and found out that the surviving spouse and the children are able to adjust status under the 204L dahil unang-una nandito sila when the beneficiary passed away and wala naman silang grounds of inadmissibility and even if the principal beneficiary at that point was 245I, kasama rin sila dun sa benefit na yon. So we were able to brief and discuss with the USCIS that the surviving spouse and the children were able to file the adjustment of status and able to get the green card. So, nandito sila. Ito yung very common na mga scenarios ng 204L.
So mga kababayan, marami pang relief pala talaga. Kaya kailangan kumonsulta po kaya sa mga abogado natin para po naman makita nyo ang inyong ang sitwasyon, ano, kung paano magbibigyan ng remedyo ito. Because when we posted it on our Facebook page that this was going to be our topic, marami sa inyo ang nagpadala ng mga questions. Mamaya, ibabato natin kay attorney yan. Yung iba ay naibato na natin. But attorney, before we move on to the humanitarian reinstatement, I want everybody to know na nabanggit nyo na kanina na yung mga pagkukonsulta sa inyo ngayon, you have free consultation right now in your law firm sa Reeves Immigration Law Group po, at attorney.
Yes, Kuya Yo, despite the new policy ng Biden administration where he was intending to pass a comprehensive immigration reform, a lot of our kababayans are asking kung pinasa na nga ba yan because maraming haka-haka at balibalita that there's already a comprehensive immigration reform. And despite that, we are bombarded with consultation. We still offer free legal consultation po sa lahat ng mga nangangailangan sa ating mga kababayan. Libre po ang consultation either through Zoom kagaya ginagawa namin ni Kuya Yo at or telephone. We don't allow in-office consultation yet, but we do Zoom consultation or telephone. You will be speaking with one of the immigration law specialists na aming law firm, who has office also in the LA, Los Angeles area and San Francisco where I am based, and also in Makati. But note mga kababayan, ang PHLV Radio alam ko abot ito hanggang sa East Coast at all parts of the world. Tandaan po ninyo, ang immigration is a federal law. So kami po mga abogado, kahit based po kami sa California, we also handle cases to any clients anywhere in the United States. Saan po man kayo nakatira, kasi ang immigration po ay federal. We are allowed to practice federal laws that includes immigration anywhere in the United States po.
Kaya po mga kaibigan, tawagan lamang po ang ating mga kaibigan sa Reeves Immigration Law Group. Ang kanilang number po sa San Francisco where Attorney Diza is right now at medyo maganda ang weather yata sa San Francisco ngayon, Attorney. Ano?
Maaraw, Kuya Yo, around 60, 65. So it's a good weather. It's sunny actually outside, sunny and breezy. The good weather in San Francisco is always almost always the same all throughout. Kaya okay pa rin, maganda pa rin.
Ang number ni attorney mga kaibigan dyan ay 415-568-3777. Again, that's 415-568-3777. Initial consultation mga kababayan ay libre para sa ating mga kababayan. And to anyone who needs some guidance sa kanilang mga kaso, sa kanilang mga petitions, sa kanilang mga situations. And for the late tuners, attorney, that just jumped in on our Facebook feed right now, we're also live on the PHLV radio channel, on the Amazon Fire TV, and also on the app and on YouTube as well. Mga kababayan, pinag-uusapan po namin ni attorney ngayong gabi, what happens to the petition if the petitioner passed away? Marami nagtanong sa inyo niyan, especially in this time of the pandemic, na talaga namang siyempre marami tayong uncertainties, hindi natin alam ang mangyayari sa ating mga mahal sa buhay, especially yung ating mga petitioner, kung maapektuhan sila nitong current pandemic. So this is a hot topic at na pinag-uusapan at marami sa inyo ang nakatutok at nagtanong din ng mga questions. And while we're at the conversation, attorney, about your phone number, number in San Francisco. We'll head over to a break. We'll remind everybody about Reeves Immigration Law Group. We will be back, mga kaibigan, with the humanitarian reinstatement, kung paano ito nagwo-work. And not only that, we have some immigration updates for you from Attorney Diza. Just a few days ago, merong inintroduce, mga kaibigan, sa ating Kongreso. So malalaman nyo yan sa pagbabalik po ng Immigration Law on Your Side right here at PHLV Radio. Just stay there.
Reeves Immigration Law Group has been representing immigrants for nearly 40 years. Reeves Immigration Law Group has been fighting for its clients through experience and expertise. With immigration lawyers you can access at reasonable fees, even on Saturday. Payment plans are also available. Call us for your immigration solutions. We can do worldwide telephone and Skype consultations. Reeves Immigration Law Group, 1-800-795-8009. Reeves Immigration Law Group has offices in Los Angeles, San Francisco, China, and Philippines. See us at www.rreeves.com. Reeves Immigration Law Group, 1-800-795-8009.
Mga kaibigan, huwag pong kalimutan, i-like na rin at i-follow ang mga social media pages ng Reeves Immigration Law Group at ni Attorney Flomi Javier Diza. And bago tayo nag-break, pinag-uusapan natin ang issue ng what happens to the petition if the petitioner passed away. And maraming mga pwedeng gawin na outline na ni attorney sa atin, ang widow and widower petition, spouse petition, and also yung 204L. And pag-usapan naman natin yan, attorney, itong nabanggit nyo na kanina, you contrasted this with the 204L, yung humanitarian reinstatement. Ano naman po ito, attorney, na humanitarian reinstatement? Paano ito na-avail ng ating mga kababayan?
It's a good topic, Kuya Yo, dahil marami sa ating mga kababayan naghihintay ang kanilang petition overseas or sa Pilipinas, at namatay ang kanilang petitioner. At wala sila sa United States. And before we discuss, by the way, Kuya Yo, ang humanitarian reinstatement, gusto ko lang balikan yung 204L. Right? For example, walang kamag-anak for the substitute sponsor. Paano kung wala silang kapatid or any of those mentioned substitute sponsor at nandito sila nung namatay ang petitioner, would they still be able to adjust? I mean, the answer there is no, generally, kung wala. But of course, titignan din yung tinatawag na exemption ng affidavit support. If they've been here in the United States for over 10 years and working, and filing their taxes, meaning that they have been contributing for the last 10 years, yung 10 quarters na sinasabi, then they are exempted. So hindi na nila kailangan ng substitute sponsor. That's something to keep in mind. Other good thing about the 204L, Kuya, yung example natin kanina, for example, si Juan nandito sa US at naghintay at nandito nung namatay ang kanyang father. Pero paano kung halimbawa Juan committed fraud? So halimbawa Juan came in with a different name. Siyempre, hindi siya pwedeng mag-adjust dahil, inadmissible siya.
Yeah. Mm-hmm.
Now, the question is, meron ba siyang qualifying relative para sa extreme hardship waiver? Now, para makapag-avail ka ng waiver, kailangan meron kang asawa, meron kang magulang na US citizen who would suffer extreme hardship. So, paano kung patay na, di ba? Yung kanyang nag-petition, yung kanyang magulang, right? Paano magkakaroon ng hardship? Now, the good thing about the 204L as well is that even with the death ng petitioner, Kuya Yo, you can still file for the waiver and the death of your parent is considered presumed hardship, which is a good thing. Ma-approve pa rin yung green card mo. So, hindi mo kailangan sabihin na ako nag-aalaga, ako ang nagdadala sa hospital, ako ang nagpapakain sa magulang ko and grant me my green card and approve my waiver, because if you don't, and I'll be deported to my home country, my father will suffer extreme hardship. Now, in that situation, we can just state that under the law, the death of the petitioner is presumed hardship already. So, hindi na kailangan ng maraming discussion. And that's one thing that our kababayan should keep in mind for the 204L. Now, then sa humanitarian reinstatement naman, Kuya Yo, as we mentioned, is that the Attorney General can reinstate because under the law, kahit sabihin mo pa yan sa immigration, i-report mo sa immigration or hindi mo i-report sa immigration that the petitioner already passed away, under the law, automatic po na-revoke yan upon death, right? So don't don't do magic by continuing with the process sa NVC, right? malalaman pagdating nyo sa embassy. Marami sa mga kababayan natin na nagbabaka sakali, baka makalusot, and stuff like that. But the reality is hindi po. Dahil hingan po ng affidavit of support ang petitioner, right? And of course, lalo na kung may edad na, hanapan pa rin ng proof that the petitioner is still alive. Kailangan ng newspaper with picture, na hawak-hawak yung updated newspaper, right? Sa mga landmarks ng United States para i-prove lang na buhay yung petitioner. So, in other words, don't process your case with the NVC. Don't submit any payments or any documentation. What you're going to do is request a reinstatement because the Attorney General can reinstate the revoked petition. Kasi automatic revoke upon death and you're asking for a discretionary approval for humanitarian reason. Right? Para makarating pa rin kayo sa United States. Ifa-file po ninyo yan kung saan po ninyo i-file saan na-i-file yung I-130 petition at kung saan po na-approve. So essentially, wag sa embassy, wag din sa National Visa Center. Mostly sa people from the West Coast, nasa CSC o California Service Center sa Laguna Niguel. Doon po ninyo ifa-file ang reinstatement request saying that I have a substitute sponsor, right? My brother would be filing the affidavit to support on my behalf. And these are the factors that you are looking and I am qualified based on these factors. So ito yung discretionary na binabanggit natin that the impact of revocation on family in the United States, especially to the relatives here, right? A disruption, what we call disruption of family unity. So ikaw na lang ang naiwan sa Pilipinas, nandito po ang magulang ninyo, dito na namatay, nandito na yung 5 kapatid mo, nandito na ang mga pamangkin mo, stuff like that, and you're the only person left in the Philippines, right? So that in order to unify the family, right? You are requesting that your dad's petition for you will be reinstated despite the death. You can also argue that you have medical problems. That's also one of the factors, right? You have some advanced serious medical illness that requires attention here. That, for example, you don't have any other place to go home dahil simple, for example, na bagyo yung bahay at wala ka nang titirhan, and also there are a lot more factors that you need to consider. Yung ties mo sa America, of course, is very important. And if you are in the United States at one point in a legal status, halimbawa dito po kayo nag-aral o nagkaroon po kayo ng non-immigrant visa, kagaya ng investor visa, for example, nandito kayo for a certain period of time, you can also make an argument saying that, my length of residency in the United States with my strong family ties and strong financial, kung may mga bangko kayo or business ties, are already in the United States. So yun po ang isusulat po natin at i-argue natin sa California Service Center and convince the service director why the revoked petition should be reinstated based on humanitarian reason. That's why it's called humanitarian reinstatement.
Dito po, attorney, sa humanitarian reinstatement na ito, kailangan pa rin ng substitute sponsor dito?
Correct. Substitute sponsor, as we mentioned, only applies for immediate family, anak, magulang at mga kapatid, right? Kasama diyan mga in-laws. So any of those people could be the substitute sponsor. But take note, Kuya Yo, even if, for example, is yung isang, let's say namatay yung petitioner, but the other parent is still alive, but the question is, siya lang yung surviving substitute sponsor na pwede, di ba? At wala nang iba. Now, for example, one of the parent is already retired, wala na ring trabaho, siya pa rin yung substitute sponsor regardless of whether or not may trabaho siya o wala. But the good thing is that you can look for a joint sponsor at that point. Kailangan mo lang talaga ng substitute sponsor para to stand on behalf of the dead petitioner, the petitioner who died or who passed away.
And yung joint sponsor, hindi na kailangang relative or kailangan pa rin?
Hindi na. Ang kailangan lang dun sa substitute sponsor ay relative, as we mentioned. Pero yung joint sponsor, for purposes of the affidavit support, any U.S. citizen over 18 who's willing to execute an affidavit support and provide financial documents.
Well, paano, attorney, if They tried the 204, 204L already and then the humanitarian reinstatement route, and then it doesn't work. Hindi nag-work po ito. Meron pa po bang iba na paraan?
Yes, Kuya, yung mga nandito sa United States, kung ma-deny sila, of course, we can refile. The same thing with the humanitarian reinstatement, because other clients would do it their own, right, at one point, and it was denied, and they come to a law firm, and we evaluate what they did, and it's not enough, right? So we can always refile. That's one of the benefits ng immigration, kasi walang double jeopardy. You can always refile anytime if you think that you have more evidence now. The other one would be if we think that USCIS committed serious error in denying the case, we can always file a motion to reopen or motion to reconsider, right? And if we think that there is a gross violation or gross disregard of the existing laws, we can always file a lawsuit. We discussed in our previous episode where we can do a mandamus or and compel USCIS to apply the law. That's one also of the advantages of having an attorney, so that we can evaluate the strength and weakness of your case, and to make sure that your packet is complete and contains the documents and legal brief that USCIS looking in order to approve the petition or the reinstatement request.
All right. So maganda mga kaibigan itong topic natin ngayon. Again, for our late tuners, welcome to Immigration Law on Your Side. We're talking about this topic, what happens to the petition if the petitioner passed away. Marami sa inyo ang nagtanong regarding that, and most of the questions that I have here nasasagot na ni attorney, including yung mga kailangan yung mga joint sponsor or substitute sponsor. Napakinggan nyo na kay Attorney Diza. And mga kababayan, marami tayong mga updates ngayon. But before tayo tumawid sa mga updates, attorney, baka meron pa po kayong gustong idagdag sa ating topic ngayon.
Yes, Kuya Yo. We mentioned that loss of a family member is a tragic event, at as we mentioned, the ability of the beneficiary to the United States, very nil na kung namatay ang petitioner. But as we discussed, there are ways for you to immigrate and be able to adjust if you're in the United States. Essentially, you just need to do a consultation and assess the case. You might be surprised na meron parang paraan para sa inyo. At believe me, Kuya Yo, marami sa mga kababayan natin that they rely on the advice of their friends and family.
Correct.
Na ito lang knowledge nila. And I have a client who just consulted this morning where, 30 years, 1990s, nandito pa siya. And she missed a lot of things, just because she feared to come out and ask attorneys. And they thought that attorneys are with the government, right? And we always emphasize sa mga viewers natin that we are immigration attorneys maintain confidentiality. So whatever you tell us, as long as that's not, not to commit a crime, right, is in confidence, right? So we don't discuss your case to anyone else, kahit magkita pa tayo sa mga public gatherings or public places, or kilala, we have a common family or friends. We don't discuss your case. We maintain a straight confidentiality of your cases. So yun po masasabi natin, and as you mentioned, this is a very tough, hot topic, but doing it right through the assistance of a lawyer, of course, it will result to a positive resolution or getting your green card.
Okay. So mga kaibigan, I'll remind you again of the phone number of Attorney Diza bago tayo tumawid sa mga updates natin. 415-568-3777. Again, that's 415-568-3777. Ang kanilang 1-800 number ay 1-800-795-8009. Website, www.rreeves.com. Mga kaibigan, maraming mga ipinost si attorney. Just a few days ago or just I think yesterday, meron mga ipinost si attorney ng mga updates sa malaman natin kung ano ang nangyayari sa immigration world. Attorney, merong inintroduce sa Kongreso itong Citizenship Act of 2021. Maganda mong pag-usapan ito. Attorney, can you brief us kung ano po itong Citizenship Act of 2021?
Yes, Kuya Yo, bago ma-approve yung proposal ni President Biden because he cannot just issue an executive order for the comprehensive immigration reform. It entails a legislative act, both the Senate and the House of Representatives para ipasa to. So the good news is that since his inauguration, no, si President Biden already sent his proposal. Ito yung Citizenship Act of 2021 to Congress para bigyan ng legal status ang mga undocumented o yung walang papel, right, sa Kongreso. So it's now introduced both in the House of Representatives and in the Senate. And of course, this will be subject to discussion, debates, and of course, probably some sort of amendments. So we'll watch out for it kung totally i-adopt ang proposal ni President Biden or there might be some changes. And again, as we mentioned, the President is pushing for a comprehensive immigration reform. It may or may not be passed, but our hope is that even if it will not be passed, may mga piecemeal, legislative act regarding immigration that will benefit mga kababayan natin, lalong-lalo na yung mga matatagal dito. As we mentioned in the past, Kuya Yo, it's also a good idea to consult an attorney now and see magkaroon ng preliminary, preliminary evaluation of your case para malaman natin, kung meron ba kayong document when you enter the United States, nandyan pa ba yung I-94 yun, nandyan pa ba yung visa nyo, meron pa ba kayong mga final sa immigration that we need to look at, before this, before this reform is passed, di ba, para malaman natin kung eligible kayo. Kasi kung may mga prior application sa USCIS, Kuya, it's also very important for us to look at kasi any kind of benefit or relief that we file with USCIS, tatanungin ka pa rin na have you filed for any immigration benefit in the past, have you committed fraud and stuff like that. So it's really important na i-pull out na yung mga records na yan. So yun yung sa update po ng Citizenship Act of 2021 and kalalabas din Kuya Yo, yung Visa Bulletin for March. The good news there is that yung employment base sa lahat ng bansa ay current. Ibig sabihin, kahit po kayo ay professional, pinipetition kayo as professional or as a, non-professionals or skilled workers, current po yan. Mapa-doctor po kayo, registered nurses or caregivers, house helpers, carpenters, pare-pareho current yan. So if you are in the United States, and you are 245I and you have a willing employer who to file a petition on your behalf, consult an attorney kasi mas mabilis pa rin ang pagkuha ng green card through employment, lalo na kung current, Kuya Yo. And marami rin sa mga kababayan natin nagtatanong na magpapapetition pa ba ako sa employer o sa aking magulang na nandito kung nandyan na yung kay Biden. My answer of course is yes as a backup, right? Kasi we don't know kung darating yung comprehensive immigration reform. At least kung magpa-petition po kayo sa magulang po ninyo o sa mga employer, prospective employer, lalo kung 245I kayo, it's still better through those means, lalo kung mabilis, Kuya Yo, dahil green card ang aasahan mo dyan. Mm-hmm. Dito sa Citizenship Act of 2021, if you read at the text ng proposal ni Biden, it's kind of legal status muna. Parang DACA lang na it won't lead to, hindi green card kaagad. So there's certain number of years na magiging legal status muna kayo, bibiglan ng work authorization, and another, while waiting for that number of years, saka pa lang kayo pwede mag-file ng green card. So the question there is that kung mayroong willing employer naman mag-petition sa inyo and the visa bulletin is current at this time, that might be a better option for you. And wag po kayong malito o wag po kayong matakot na pag nakfilean kayo ng petition from either your family member, your parent mo, kapatid mo, or employer mo, makaka-apekto sa ipapasa ni Biden. The answer is a big no. In fact, they might supplement each other, right? The worst thing is, of course, nagsayang ka lang ng pera dun sa pag-petition. But I would say na hindi ka magsasayang kasi ito'y leading to green card itong route na to, right? So yung kay Biden, as we mentioned, is illegal status. So either way, kung green card naman ang ibibigay dun sa comprehensive immigration reform, at least you have some kind of backup, right? Para magkaroon ka man lang ng peace of mind. As I mentioned, yung kaninang client na may magulang siya dito, mayroon siyang kapatid na he was in 1990s, walang ginawa, walang petition. Ngayon na lang siya magtatanong dahil pa-retire na. So paano niya makukuha ang retirement kung wala siyang status? So that's the second option, visa bulletin for employment base, and F2As, yung mga anak ng green card holder na minor or asawa mo ay green card holder lang, and if you are in the United States, pwede na rin mag-file ng adjustment as long as you are in status or 245I eligible po kayo. So those are some of the good news, Kuya Yo, at ma-mention na rin natin yung notice to appear policy ng Immigration Custom Enforcement na bago na yan. Now, if you remember during President Trump's time, right, any person who are here unlawfully, illegally, let's say nag-cross the border or nag-overstay, are subject to deportation. Pero ngayon, nilimit na lang nila sa mga people who are a threat to the national security, or committed serious criminal records or who have a serious criminal conviction. So very limited na po yung pag-issue ng notice to appear. So keep in mind the current administration is trying to undo some of the harmful for immigration communities and also harmful policies of the prior administration. Tinatanggal na po yan, and hopefully hinay-hinay susunod na po ang comprehensive immigration reform, or kung hindi man maipasa yun, any executive order or piecemeal legislative act that would help you legalize your status in the United States.
Maraming salamat, Attorney, sa mga updates mo na yan. And as I said kanina, Attorney, before the show, maraming mga nagpadala ng mga questions, pero we just handpicked a few. We'll just throw this one out to you because of the current pandemic. Although the quarantine in some of the countries abroad, even here, even in the Philippines, they're starting to relax. Pero ang isa sa mga tinapon sa ating tanong is the extension daw po, Attorney, ng mga tourist visas. Pag nag-request po ba ng, halimbawa, nandito sa Amerika, yung kanilang relative, ayaw mo na umuwi dahil magko-quarantine doon, hassle and everything, would rather wait for a few months before going home. Nabibigyan ba ng extension ang mga tourist ngayon at mga naka-tourist visa, Attorney?
Yes, Kuya Yo. Very liberal or lenient ang USCIS when it comes to approving yung extension, just because of the COVID, the pandemic, and there are situations that beyond the control of the applicant as well, where the airline companies would just postpone yung flight, di ba? Sasabihin na walang flight ngayon, so wala, ma-postpone na, so overstay ka na or patapos na yung extension mo. Our recommendation is if you intend to stay in the United States, you still have to file the extension para hindi ma-violate yung status po ninyo. Right? As we mentioned, matagal nga lang ang approval, Kuya Yo, and I've seen clients where they file it 3 months before mag-expire yung kanilang I-94. Wala pang result, patapos na ulit yung another 6 months. So our recommendation is to leave bago mag 6 months yung stay po ninyo. Right? So let's say ang expiration ng I-94 mo is January 1, right? Yun yung last day mo na dapat nandito ka, and nag-file ka halimbawa November pa, at kung wala pa yan in June, which is 6 months from January, right, kailangan nang umuwi kayo kung plano nyo umuwi. Right? Kasi kung uwi kayo after June, that's more than 6 months from you allowed to stay, and then you accrue 3-year bar. Right? Even if wala pang result, I will recommend, kasi paano kung na-deny? I would say, as we mentioned, Kuya Yo, mas maraming approval ngayon. But what if, right, lalo kung kayo lang ang gumawa and there's something that you failed to, you mentioned, or kulang kayo ng evidence or nag-request ng evidence, hindi kayo nakapag-respond and they deny the case, it's still better to leave bago mag 6 months po yung overstay para ma-avoid po ninyo ang tawag nito, ang 3-year bar. Now, let's say umuwi po kayo ng walang result, ma-approve yan o ma-deny, right? Technically, you are still in status. So, wala dapat issue when you come back, which is a good thing because you exercise good faith by filing an extension of your status while you are in the United States.
And last na lang, Attorney, dito sa tanong na ito, inulan tayo ng tanong regarding that. Nabanggit nyo yung dadating ka na sa expiration ng inyong 6 months na validity ng inyong stay dito as a tourist. Yung sinabi nyong kailangan lumabas or umuwi, tinatanong dito, qualified ba kung meron akong relatives sa Canada? I go to my relative to Canada, I stay there for a while because I can stay there too because I have my visa din siya sa Canada, Attorney. Will that qualify as lumabas na siya and multiple entry naman kasi yung kanyang visa dito sa US?
Yes, Kuya Yo. Actually, that's already leaving the US, which is a good thing. But if he's planning to come back, right, that's another issue there because they're going to ask how long did you stay in the US. So for example, nag-stay na siya ng 6 months or let's say, siyempre nag-extend at naghintay pa ng result, wala at umuwi. So let's say 8 months total siya sa Amerika at bumalik siya. Right after 2 weeks in Canada or after 2 months in Canada, bumalik ulit sa United States. Siyempre titignan yun, Kuya Yo. Right? So that becomes an issue. Pero hindi na siya babalik sa US for the next 6 months or 1 year, walang issue sa kanya. Pero kung babalik siya kaagad, of course, subject to kahit umuwi siya sa Pilipinas o Canada, pero pabalik ulit sa United States, of course, that would become an issue because they're going to ask, how do you support yourself for 6 months or 8 months, right? And what's your plan and what you're going to do again in the US, right? So yung mga yon, you just try to avoid yung confrontation at the inspection, yung primary inspection, because I have seen many clients consulting with me, Kuya Yo, where even during this pandemic, ang dami pa rin nilang expedited removal. You believe me, like, they do their job by asking questions, and stuff like that. And if the applicant is unable to answer, correctly or may mabanggit siyang hindi maganda doon sa tanong, during secondary inspection, nagkakaroon ng airport to airport. And not only the airport to airport problem, nagkakaroon ng expedited removal, nagkakaroon ng fraud finding dahil ang intent mo pala is magtrabaho, bakit ka gumagamit ng tourist visa? Ang intent mo pala is mag-asawa ng fiancé mo, bakit ka gumagamit ng tourist visa? So just keep that in mind when you come back because if you're using a tourist visa, you're coming here for a temporary business or pleasure or visiting family members. Yun po ang purpose ng B1, B2 visa. Hindi po para maghanap ng paraan para mag-stay here permanently. You can do that once you enter the US, but not while you're still outside and planning to enter or while at the port of entry.
Mm-hmm. Nako, maraming salamat, attorney, sa mga paliwanag niyo yan. At I'm sure itong marami pang mga ibang gusto magtanong, mga kaibigan. Again, free consultation. Reeves Immigration Law Group, 415-568-3777. Again, area code 415-568-3777. Sulat na po yan para po tawagan niyo si Attorney Flomi Javier Diza. Attorney, baka meron po kayong ibang messages sa ating viewers.
Yes, Kuya. Kung may mga tanong po sila at mga follow-up questions, you can always message us through the PHLV radio where you're going to broadcast yung ating discussion, right? They can always message us there and tag lang po ninyo kami ni Kuya Yo. We'll be gladly happy to respond to your questions. But of course, remember yung pinag-usapan ni Kuya Yo ay for informational purposes only. Hindi po ito strong legal advice para sa inyo at sundan. Of course, every case has a different assessment. It's still better to talk to an immigration attorney to assess your case, right? So we're very lucky to have PHLV Radio to do a public service to inform the public regarding US immigration. But of course, mas maganda pa rin po kung magkaroon kayo ng personal consultation sa abogado. At we mentioned Reeves Immigration Law Group, marami po kaming mga lawyers who would render free legal consultation. And in fact, even if you intend to hire our services, Kuya Yo, marami kaming mga payment plans din. It's not something that you pay as a front, right? We understand the difficulty of earning money in the United States, and especially this time of pandemic where marami sa mga kababayan natin ang na-lay off at nag-rely sa unemployment. We understand the financial difficulties of our kababayan, especially during this time.
Mm-hmm. Okay, so mga kababayan, may payment plan. Actually, isa yan, attorney, dito sa mga nakasulat dito. may nagtanong din. Okay, so yeah, nasagot na ni attorney. Meron pong payment plan sa Reeves Immigration Law Group. Again, www.rreeves.com. So again, attorney, maraming salamat sa inyong mga paliwanag regarding our topic today. What happens to the petition if the petitioner passed away? And also sa mga immigration updates. Always a pleasure having you here, attorney, sa PHLV Radio. Maraming salamat po, attorney. Baka meron kayong mga gustong babatiin, attorney, while you're still on the air.
Yeah, babatiin ko lahat, of course, ng ating mga viewers. Keep on listening and watching our show and all the PHLV radio shows. Kuya Yo, paki-share na rin po ang ating ang programa natin para makita rin ng ibang mga friends nyo sa Facebook. And also binabati ko rin ang aking dalawang dalagita o mga babies, Sophia and Sasha. They're also watching us every time na pinopost ito sa Facebook page. At it's always a pleasure to be here, Kuya Yo, and thank you for inviting us and educating ng ating mga listeners and viewers regarding US immigration.
Maraming salamat. Thank you so much, Attorney. It's already the end of February, and I guess we're marking the first year na hindi tayo nagkikita physically dito sa studio. I think it was February of 2020 when you were last here at the studio ng PHLV Radio. Hopefully malapit na we can see each other again. But in the meantime, wala namang hadlang sa pagsiserbisyo publiko ng Reeves Immigration Law Group, at we're doing everything we can. We have this Zoom, so para naman we are still able to communicate with you guys lahat ng mga information about immigration. So again, from the PHLV Radio Studios here sa Las Vegas, ito po si Kuya Yo. Huwag pong kalimutan, padala lamang ang inyong mga questions sa info@phlvradio.com o kaya sa Facebook page natin o kaya sa website natin. Marami attorney mo nagpapadala ng mga questions din sa website. So maraming salamat po. In behalf of Attorney Flomi Javier Diza from California, from San Francisco, California at Reeves Immigration Law Group. Ito po si Kuya Yo. We will see you next time right here at PHLV Radio.
Reeves Immigration Law Group has been representing immigrants for nearly 40 years. Reeves Immigration Law Group has been fighting for its clients through experience and expertise. With immigration lawyers you can access at reasonable fees, even on Saturday. Payment plans are also available. Call us for your immigration solutions. We can do worldwide telephone and Skype consultations. Reeves Immigration Law Group, 1-800-795-8009. Reeves Immigration Law Group has offices in Los Angeles, San Francisco, China, and Philippines. See us at www.rreeves.com. Reeves Immigration Law Group, 1-800-795-8009.
Reeves Immigration Law Group has just brought you Immigration Law on Your Side. Wednesdays, 7 p.m. Pacific on PHLV Radio. This is your Filipino radio experience in Las Vegas. PHLV Radio.